Good afternoon, ladies and gentlemen. This is the 1 p.m. calendar for the State Court of Clayton County Criminal Motions Calendar and Courtroom 304. I'm Judge Tammy Long Hayward. First thing I need is for everyone who does not already have your first and last name on the screen, please rename yourself. If you are unable to unmute to let us know that you're here, or if there's something technical going on, then if we see your name on the screen, then you'll get credit for being here. But if we don't know who you are, or if you're just giving us a phone designation, that is not helpful. So please go ahead and rename yourself. I'm going to call the calendar and then we'll have announcements for the motions calendar. All right, first case on the calendar for the 1 p.m. Motions calendar is Christopher Campbell, Gabriel Winters. That case is closed. There was a motion to suppress, but that case has been closed by a plea. Okay. Next case is Lana Harris. Lana Harris.
Madison Gibbs for Miss Kimberly Berry for Lana Harris. We were just served discovery on July 17th, and we still have not, we're not sure if there is video available or not at this time. And so, Your Honor, we would just ask for a one-time reset to give us time to review the discovery and determine if we need to move forward with any motions.
Mr. Tipton?
Your Honor, there should have been a notice regarding whether or not video was present in our whether or not video was present in the discovery we sent out. This motion has not been particularized. State would request that this motion be dismissed.
When did you receive the discovery, ma'am?
July 17th, and we're still missing pieces of the discovery.
All right, so move the motion to pretrial. So that means that when your case is called on the trial calendar, be prepared to argue the motion that should be particularized prior to that.
Yes, Your Honor, we will particularize. All right, and we'll just receive notice in the mail?
Yes.
Thank you, Your Honor. That concludes my business. May I be excused?
You may.
Good seeing you, Ms. Gibbs. Have a good day.
You as well. Bye. Thank you.
All right. Winfair Deodrick Lee.
Hi, Your Honor. Mr. Lee and I are present in the courtroom.
Okay. So this is a motion to suppress. Are we ready to go forward?
We are actually ready to enter a
right
guilty plea. We have it all negotiated and are ready to go.
Are we ready, Mr. Tipton?
Your Honor, I just need to amend the speed on there. I wasn't sure if Attorney Morgan was.
All right. So, Ms. Morgan, just give me a minute for him to amend the accusation, and as soon as we've done that, I'll finish the call of the calendar, and we'll come back to it.
Thank you, Your Honor.
All right, Officer Shelby, you might want to mute for me. There you go. All right. So Jared Alexander Major, that case is closed. And this was a motion to and the motion was withdrawn. So Major that case is closed. Next case is Elizabeth Montier Mascater. And this is a motion for immunity.
Judge, that motion was filed by my previous trial partner. I'm not going to be going forward on the motion for immunity. Although Ms. Mascater does have some supporters, the alleged victim, and some family members in the courtroom. I believe Mr. Tipton potentially wanted to have a bench conference about that at the appropriate time.
That is correct, Your Honor.
But I'm withdrawing the motion.
Hold on. A conference including me, or are y'all working something out?
A conference including you, Your Honor. There's this case has some very unique circumstances.
Okay, give me a minute, and Mr. Lynch, do you have a different device available so it can be a little bit more private?
I should be able to, thank you, Judge. I should be able to get on my phone. I'll.
Okay, all right. Well, let me know when you get that set up and then I'll put us in a breakout room.
And Your Honor, if it would be easier for Mr. Lynch, he can come into my office and we can and he can just sit in here with me.
Okay. Yeah, y'all work that out and let me know what I'm doing. All right, Patrick Lamont Moss. This is
Your
a motion.
Honor,
Yes.
yes, Your Honor, Attorney Tortorella, Lister, Holton, Dennis, on behalf of Mr. Patrick Moss, we're ready to move forward on the motion to suppress.
Mr. Moss is present in the courtroom, I believe.
Your Honor,
Yes.
our officer is present. After speaking with Attorney Tortorella, we're only going to need Officer Shelby on this matter. I would like to have a brief breakout room with Officer Shelby to go over an unintelligible portion of the video. It'll
Okay.
be less than 2 minutes.
All right, so I'll put you and Officer Shelby in a breakout room as soon as we finish the call of the calendar. William Blake Reese, Steve Fry.
Your Honor, that motion's moot now. The state has consented.
Okay, motion is moot. Will be dismissed because it's no longer necessary. Gary Liebert Williams, we've already determined that that case is going to be continued. Is that correct?
That is correct, Your Honor.
Yes, Your Honor.
Trial date.
And Mr. Williams is on the Zoom call, Your Honor.
All right,
Yeah,
Mr.
Mara.
Williams, this motion is going to be heard on the date that your case is called to trial. That way, all of the witnesses will be there. If the motion is what we call dispositive, meaning that it will change the nature of the case, then that way we'll have everybody there so that we can deal with it at the appropriate time, okay?
Okay, so my lawyer will tell me when the next court date is.
Yes, sir. You're going to receive it in the mail. You should be receiving your notices in the mail, but please keep in touch with your attorneys so that they can direct you on anything that they may need your assistance with, and what any changes that might be made.
Okay, thank you, Your Honor. May I be
You're
dismissed?
welcome. Yes, sir. You're free to go at this time. All right. So you all need be in a breakout room for Major, is it? No, Mark Mascater. Nope, sorry. Yeah, Mascater. Lee is ready for a plea, and then you all need a breakout room with the officer in Moss before we proceed with the hearing. So first things first, can we take this plea so the attorney can and all of those witnesses can be excused?
Yes, Your Honor. I amended the accusation.
All right.
All right, Mr. Lee, can you join me?
We got that done, Mr. Tipton, or am I rushing you?
I've already got it done, Your Honor.
All right, thank you. All right. So this is, one second. All right, this is State of Georgia versus Winfair Deodric Lee, 2025 CR 03346. Mr. Lee is represented by Attorney Courtney Morgan, who is present with him in the courtroom. Mr. Lee is charged with speeding, count 1, tinting violation, count 2, and failure to have license on person, count 3. Ms. Morgan, what is your client plead to the offenses before the court?
The plea is only to a reduced speed in count 1, count 2, and 3 are to be null crossed.
All right. Mr. Lee, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right. And is the plea to count 1, the amended speed, is that a guilty plea, Ms. Morgan?
Nolo, please, Your Honor.
All right. So by entering a plea of nolo to count 1, the amended speed, counts 2 and 3 will be no pros per the agreement between the attorneys. Mr. Lee, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And sir, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. On August 5th, 2024, officers with the Morrow Police Department did observe the defendant before you, Mr. Winferry Lee, excuse me, driving a Chevrolet Suburban at a speed of 87 miles per hour in a zone clearly marked for 65 miles per hour. For plea negotiations, the state is reducing the speed to 82 miles per hour, and the fine will be a $200 fine draw. Nothing further from the state.
All right, so Ms. Morgan, is your client prepared to pay today, or does he need additional time? And the caveat is the fine is $200, but the total is going to be $298 because of the surcharges.
He is able to pay today, Your Honor.
All right, so Mr. Lee, this is what I'm going to ask you to do. You're going to go downstairs to the second floor. When you come back through the double doors into the hallway, you're going to go to your left to the traffic court window. They're going to accept your payment and they'll give you the necessary paperwork. And once you've done that, your case will be complete, but please do not leave the courthouse today without making that happen, okay?
Yes, Your Honor.
All right, and slow down. Can you do that for me, please?
Yeah.
All
I'm
right.
amazed he got a Chevrolet Suburban to go that fast.
I know, that's what I was thinking. That Chevy Suburban was moving. All right, slow down for me, Mr. Lee. Go on down to the second floor and take care of that.
Thank you, Your Honor.
All right, thank you, Ms. Morgan.
Have a good one, Miss Morgan.
All right, take care, y'all. All right, so conference with Officer Shelby, and then the conference with me and Mr. Lynch. So
Your Honor,
Officer-
Mr.
Yes?
Lynch is walking into my office now. Would you be fine with us going ahead and getting that?
Yeah, that's fine. We'll do that first.
All right, thank you.
Okay, so recreate. All right, so I'm gonna put Mr. Tipton, I'll put your office in breakout room number 1. And then since Mr. Lynch is gonna join you there, I'll just come into breakout room when y'all are sit already in.
Yes, Your Honor. I'm gonna go. He said he's on his way now. I'm gonna go run and grab him from the lobby now.
All right, thank you. All right, ladies and gentlemen, we'll be back. The only thing we need to do is have these brief conferences, and then we'll proceed with the hearing.
Your Honor, Mr. Lynch and I are in the breakout room at the court's convenience.
All right, so Officer Shelby, I'm gonna put you in the breakout room with Mr. Tipton. Ms. Val, we're gonna need an interpreter for the Mascator case. And that interpreter, I believe, Miss Powell, if you're listening, I'm sorry. That interpreter, I believe, needs to be the language spoken in the Philippines, which is, I believe, Tagalog. If Mr. Lynch is gonna verify that, but we're gonna give a 2-week continuance, for them to be able to verify language and get an interpreter, for Miss Mascator.
If you could just email me what type of interpreter so that I can fill out the form correctly.
Okay, he's verifying it now, and then Mr. Lynch, if you could just email, he's not there yet, but Ms. Tortorello, if you could just remind Mr. Lynch to email that language need to Ms. Val. Officer
Your Honor.
Shelby, I put you to the breakout room with Mr. Tipton, he should be in there. And then we'll move forward in a moment as soon as Mr. Tipton is ready.
Thank you, Your Honor.
Thank you.
The answer's probably no, but if I was, yeah.
Your Honor, we're out of the breakout room and we're ready when the court's pleasure.
I'm ready. Are we ready to go forward on the motion?
Defense is ready, Your Honor.
All right, state.
State's ready, Your Honor.
All right, so, this is State of Georgia versus William Blake Reese. No, sorry. This is Moss. Is it Moss?
Yes, Your Honor.
I'm sorry, Patrick Lamont Moss. Mr. Moss is on case 2022 CR 03474. Count 1, driving under the influence. Count 2, driving under the influence less safe. Count 3, improper lane change. Mr. Moss is represented by the law firm of Lister Holton Dennis, attorney MJ Tortorello. The state is represented by Assistant Solicitor General William Tipton. Both parties are announcing ready for the motions hearing. And Mr. Tipton, you may begin.
Your Honor, before we
I'm so,
Go ahead, Ms. Tortorello.
I'm sorry. I just wanted to advise the court that the defense does have an opening statement.
Okay.
Okay, and just before I move forward, Your Honor, I would like to invoke the rule of sequestration for witnesses under OCGA 24-6-615 before I begin my opening statement. And furthermore, state and defense has stipulated to play relevant portions of Officer Shelby's body-worn camera video for this hearing.
Okay, the court will accept that stipulation. The court will invoke the rule of sequestration. If there are any witnesses who are scheduled to testify at this point, please let me know. If you're, I can put you in a breakout room. If you're by video, if you're in the courtroom, then I'll go ahead and put the courtroom in a breakout room until such time as we need your testimony.
And Your Honor, Attorney Tortorello and I agreed previously that the only issue we'd be going forward on was the implied consent. If that's the case, then the only person we need to have present is Officer Shelby. So no one else would be testifying today.
All right, Ms. Tortorello?
That's correct, Your Honor.
Okay, so we have the one witness who is here. All right, Ms. Tortorello, does the state wish to make an opening statement?
State does not, Your Honor. State just wishes to present evidence.
All right, Ms. Tortorello?
Yes, Your Honor. We're here to ask Your Honor to suppress evidence of Mr. Patrick Moss's blood test results provided by the GBI. Mr. Moss consented to the state-administered chemical test of his blood while under the coercion of Officer Stanley Shelby of the Clayton County Police Department, which violated my client's constitutional rights under the Fourth Amendment. Therefore, Mr. Moss's consent was not voluntary. This is supported by Kendrick v. State 335, Georgia App 766-2015. Therefore, because Mr. Moss's consent was not voluntary, defense is asking this honorable court to suppress evidence of Mr. Moss's blood alcohol concentration level.
All right. Mr. Tipton?
Yes, Your Honor. At this time, the state's going to call Officer Shelby to the Zoom call.
All right, Officer Shelby, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am, I do.
All right. You can put your hand out. Mr. Tipton, your witness.
Yes, Your Honor. Officer, would you please state your name for the record and spell it?
Yeah, Officer Stanley Shelby, last name Shelby, Shelby.
Okay. And Officer Shelby, how are you currently employed?
Through the Clayton County Police Department.
I'm sorry, Mr. Tipton, you're breaking up. Can you repeat, please?
How long have you been with Clayton County, Officer Shelby?
Right now, a little bit over 7.5 years.
Okay. Were you working for Clayton County on May 2nd of 2021?
Yes, sir, I was.
Okay. Are you post certified?
Correct. Yes, sir, I am.
Were you post certified on that date?
Yes, sir, I was.
Being post certified, are you authorized to make arrests involving DUI drivers?
Yes, sir, I am.
And have you been trained on how to read implied consent cards?
Yes, sir.
Okay. On this date, did you have a reason to go to Terra Boulevard near Bridgeport Lane?
Yes, sir. We from dispatch. I was dispatched in reference to a vehicle accident.
Okay. Did you effectuate an arrest on the defendant, Mr. Pat Moss?
Yes, sir. After investigating, after speaking with all parties. Yes, sir.
Okay. Upon effectuating that arrest, did you read Mr. Moss Georgia implied consent?
Yes, sir. I did.
Did he consent at that time?
He did.
Okay. Did you take him to the Clayton County Jail?
Yes, sir. I did take him to the jail. Yes, sir. I did.
Okay. Did he consent at the Clayton County Jail?
Yes, he consented when asked. Yes, sir. He did.
How did he consent?
Based on the video, I think he appeared to say yes prior to him nodding his head. When I asked him the last time, he nodded his head.
I got you. Okay. And I just want to make sure I understand. Did he consent when you initially before you put him in handcuffs, or no?
No, he didn't. At that point, no, sir, he did not. He got it.
Okay. Your Honor, at this time, I would like to share my screen. We defense and state have stipulated to the video coming in, and we have stipulated to a timestamp to start at. I would like to publish to the court the timestamp from 5 minutes and 32 seconds to 9 minutes of Officer Shelby's video.
All right, you may.
Thank you, Your Honor. Your Honor, I apologize. I'm having a little bit of technical difficulties for some reason.
All right.
Let me see. All right, Your Honor, I am sharing video and audio starting at 5 minutes and 32 seconds.
Okay.
I will stop prior to 9 minutes.
I know it all day long. Hey, bro, turn around and talk to me, brother. All right. You sure you ain't been drinking today?
No, I had a couple drinks last night.
Last night? What about today? I'm looking at your eyes, brother. Your eyes are bloodshot, brother. You got any conditions, anything?
Not like that. Not like that.
You
No.
say you been drinking? How long ago you drank some?
Last night. I'm good.
But you good? All right. Like, what you had to drink last night? Huh?
I'm good.
Huh?
A couple of beers.
Couple of beers? I got you. Okay. Hey, sir, you want to submit to any kind of field sobriety test for me today? To see if you've been drinking or not today?
I would not like to.
Huh?
I would not like to.
You would not like to?
No.
I got you. Stand right there for me, brother. All right. Stand around so you can hear this. I'm going to read this to you, okay? All right. The state of Georgia has conditioned your privilege to drive upon the highways of the state upon your submission to state administered chemical tests for your blood, breath, urine, and other bodily substances for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit blood or urine testing may be offered into evidence against you at a trial. If you submit to testing, and results indicate alcohol concentration of 0.08 grams or more, your Georgia driver's license privilege to drive on the highway of the state may be suspended for the minimum period of 1 year. After submitting to the requested state test, you are entitled to additional chemical tests of your blood, breath, urine, and other bodily substances at your own expense and from qualified personnel of your own choosing. Will you submit to the state administered chemical test of your Will you submit to the state administered chemical test of your designated? Do you submit? You want to go to the testing?
You want to do the testing? What you think?
If you refuse, you can.
If I refuse what?
Not. Do you? All right. Okay.
I'm asking you.
No, you can't ask me. It ain't up to me. It's up to you. All right. I got you.
Not like.
All right, go ahead and turn around for me, brother. Hey. Turn around.
State is stopping the video at 8 minutes and 50 seconds. Officer Shelby, can you tell me what we just saw?
Yeah, that was me investigating once I determined or not determined when I had probable cause to ask him about if he had been drinking. That's what my questioning, asked him about if he had been drinking prior to the accident.
Okay, and did you read him implied?
Yes, sir, I did read him implied consent. 13, I think in my report, it was around like 13 hours and 10 minutes, 13:10.
Okay, thank you, sir. And did he agree or decline?
Yeah, he declined.
Thank you. If you're on, give me one moment on the portion of the video that state and defense stipulate. Your Honor, state is starting the video at 1 hour, 47 minutes and 54 seconds.
Which phone you want to get numbers out of? What phone you want to get numbers out of?
Yeah, be over there to help out.
Yeah. To call here.
Hey, brother, you want to sign? Hey, Mr. Mouse, you want to sign this, brother?
I'm gonna sign.
Hold on. Hey, Amador, where he signed it on here? Oh, to my, to my where it says signature of driver, and that's on the place that he signed. As far as the chemical test and all that, he don't sign. We don't mark none of that, right? Just the blood test. You said, did he accept me? Did he agree to the blood test? You agree to the blood test, brother?
No, we gotta admission to guilt.
Huh?
I admit the blood test. What you saying?
Yeah, he already said he admit to the guilt, but did he need to take blood test? Yeah, you got to submit to the blood test. All right. So that okay. Just sign right here, brother. It says driver right here under that. Right here, with the second line.
But I'm not.
Huh?
For this, I'm not amending anything.
No, this is so you can be able to drive when you get out of here until your court date. This one right here, the second line.
Yeah.
Yeah, not the top one, the second line, not this one. The second, yes, sign. Go ahead, start signing. Go ahead. Okay. So it's one of the, all right. All right, so as far as one of these, he said where it says driver refused, chemical test, huh? Yeah, chemical test.
It's happening at 1 hour, 54 seconds. Officer Shelby, can you tell us what just happened?
At that point, I was getting a little bit more information from a seasoned officer, Officer Eric Amador. That's who I was on the phone with to make sure I filled out that paperwork correctly. And that was in reference to the implied consent and in reference to him submitting to the blood test.
Okay. At this point, did Mr. Moss consent?
Yes, sir. With the nodding of his head, yes, sir. I took that as a yes.
Okay. Did he ask you any questions about what he was signing?
Yeah, he only asked, is like, is this admitting to me drinking? I said no.
Okay. I have no further questions at this time. Your Honor, I'm going to leave my screen share up in case Ms. Tortorello needs to use the video.
That's fine, Ms. Tortorello.
Yes, Your Honor. Hold on just a second. Let me pull something up here. Okay. You're Officer Shelby, correct?
Yes, ma'am, I am.
Okay. And you're currently a police officer at the Clayton County Police Department?
Yes, ma'am, I am.
And you were employed by the Clayton County Police Department on May 2nd, 2021, right?
Yes, ma'am.
And on said date, around 12:45 p.m., you were dispatched to Terra Boulevard and Bridgeport Lane in Jonesboro, correct?
Yes, ma'am, that is correct.
Okay. And you were dispatched in reference to a 3-vehicle accident, right?
Yes, ma'am, that is correct.
Okay. And upon arrival, you encountered my client, Mr. Patrick Moss, right?
Yes, ma'am.
Okay. And he was sitting in the driver's seat of his black 2007 Lexus ES 350, right?
Yes, ma'am.
And you eventually began your DUI investigation on Mr. Moss, correct?
Yes, ma'am.
And Mr. Moss declined to do a standardized field sobriety test, right?
Yes, ma'am. On scene. Yes, ma'am.
You then read the implied consent warning card to Mr. Moss, right?
Yes, ma'am.
And this implied consent warning card was kept on your person, correct?
Yes, ma'am. It was inside my wallet. Yes, ma'am.
Okay. And the color of the card was green, right?
Correct. Yes, ma'am.
And the implied consent warning card was legal at the time of Mr. Moss's arrest, correct?
Yes, ma'am. It was issued to me. Yes, ma'am. Through my department. Yes, ma'am.
Okay. And you had a cordial tone during the reading of the implied consent, right?
Correct. Yes, ma'am.
And there was no argument during the reading of the implied consent warning, correct?
No, ma'am. No argument. Not that I remember. No, ma'am.
Okay. And you didn't designate a test when you read the implied consent warning, right?
I asked him, did he want to submit to field sobriety test? And he declined. Yes, ma'am. Prior to me reading implied consent.
Okay. But when you read the implied consent warning, at the end of the warning, usually officers designate a test. You didn't do so at that point in time, correct?
Correct. Yes, ma'am.
Okay. And Mr. Moss refused implied consent after it was read at the scene, correct?
Yes, ma'am.
And you didn't include the refusal Mr. Moss made at the scene in your report, correct?
Let me see. No, ma'am, I don't, I'm looking at my report. No, ma'am, I didn't add that to the report. No, ma'am.
Okay. Why didn't you include the refusal in your report?
That I couldn't, that's been 3 years ago. I couldn't tell you why it wasn't placed in there, ma'am.
Okay. Would you agree with me that you placed Mr. Moss under arrest after he refused the implied consent?
That is correct.
And would you agree with me that your arrest of Mr. Moss after his refusal is timed in the video around 8 minutes and 36 seconds?
Yes, ma'am, a little bit. What was the time you given? Because mine is around like 13:10, somewhere in there.
The arrest. I'm not talking about the implied consent. The arrest in the timing of your video, it
Mhm.
was would you agree with me that it was around 8 minutes and 36 seconds that he was arrested?
8 minutes. I can't be for sure about that. But if
If I could bring up the body cam, Mr. Tipton,
It's up.
I-
Where do you want it?
around 8 minutes and 30
Georgia.
seconds.
It ain't up to me, it's up to you.
8 minutes and 23 seconds.
yes,
May
ma'am,
I-
around that time. Yes, ma'am.
You agree with me, officer?
Yes, ma'am.
Okay, well, we can move on then. So over an hour had passed between the time you arrested Mr. Moss and the time that he was being processed in the jail, correct?
Correct.
From the time of arrest, about over an hour had passed. Would you agree with me? From the time of arrest to the time that he arrived at the jail?
Correct. Yes, ma'am. Approximately. Yes, ma'am.
And at this point in time, Mr. Moss is going through the intake process at the jail. Is that right?
Yes, ma'am. On the second part of the video. Yes, ma'am.
Yes. And you asked him again after his initial refusal at the scene if he would agree to the blood test, right?
Yes, ma'am. And that was that's when I don't know if it's cut out, but I think that's when I had spoke to the nurses. The nurses said, I think at the point they said that they couldn't or wouldn't take any blood unless they had a warrant or his admission saying that he wanted to take the blood test. Yes, ma'am.
Okay. And when you asked him again, he was in custody inside the jail, correct?
Correct. Yes, ma'am.
And you did not reread the implied consent warning from your green card again. Isn't that
No,
right?
ma'am. No, ma'am, I did not.
And he again refused after you asked him this question, correct?
No, I don't think he refused. He was asking me, would it show him an admission of guilt? Would he show him that he's guilty? And I said no.
Let me go to the around 1 hour and 48 seconds, please, of the video.
Let me go check.
I've got at 1 hour 48 minutes and 3 seconds.
Numbers out of. What phone you want to get numbers out of?
Yeah, be over there to help out.
Yeah.
Hey, brother, you want to sign? Hey, get them out. You want to sign this, brother?
I'm gonna sign.
Hold on. Hey, Amador, where he signed it on here? Oh, to my, Oh, to my where it says signature of driver, and that's on the place that he signed. As far as the chemical test and all that, he don't sign. We don't mark none of that, right? Just the blood test. You said, did he accept me? Did he agree to the blood test? You agree to the blood test, brother?
Stop it right there, please.
Yeah, he already said he.
Stopped at 1 hour, 49 minutes and 33 seconds.
Officer, would you agree that when you asked him the question, his initial response was no, followed by other statements?
I couldn't hear a no in there, ma'am. I couldn't.
Okay. So what was the reason why you asked him against? Because he initially refused the test before, correct?
Correct, yes, ma'am.
Okay. And you also advised him he had already admitted to the guilt, correct?
Repeat that, ma'am. You kind of broke up a little bit. I'm sorry.
Sorry. You then, after you asked him the question again about whether he wanted to take the state-administered blood test, you then he responded, and then you told him he had already admitted to the guilt. Is that right?
Yeah, of him drinking, yes, ma'am. Of him submitting to of him admitting to drinking, yes, ma'am.
And would you say you told him he had already admitted to the guilt because you refused initially when you read the implied consent at the scene of the accident?
No, man, that's not what I was saying. He was guilty. He said what I said was he admitted to drinking, having drinks. Yes, ma'am.
Okay. What is your understanding of refusal, officer? When somebody refuses?
Yeah, refuses to go forward, refuses to take tests, or refusal or whatever in reference we're talking about. Yes, ma'am.
And you understand that the refusal can be used against them during trial, correct?
Yes, ma'am.
And you also understand that it could be used as an admission of guilt at trial, correct?
Correct. Yes, ma'am.
Okay. Then you tell him in the video, quote, "But you need to take the blood test," end quote. Is that correct?
I don't know if I use the word need.
We can keep playing the video,
Yes,
please.
ma'am.
It's beginning the video at 1 hour, 3 minutes, 33 seconds.
Get to the guilt, but did he need to take blood test? Yeah, you got to submit to the blood test. All right. So that
Okay. You could stop it, Mr. Tipton. Thank you.
State is stopping the video at 1 hour, 49 minutes and 49 seconds.
So I'm asking again, did you tell him, quote, "But you need to take the blood test," end quote?
Yes, ma'am. Based on the video, yes, ma'am. It did. I did say that part. Yes, ma'am.
Okay. Then Mr. Moss stares at you for a few seconds, correct?
No, after I said you need, he nodded.
Okay.
It was almost simultaneously when I said you need to, and he nodded.
Okay. Can you go back to 1 minute and 48, 1 hour and 48 minutes, please?
Yes.
Thank you.
This is 1 hour, 3.
Numbers out of. What phone you want to get numbers out of?
You gotta be over there to help out.
Yeah. To call here though.
hey, brother, you want to sign? Hey, get them out. You want to sign this, brother? Hold on. Hey, Amador, where he signed it on here? Oh, to my, to my where it says signature of driver, and that's on the place that he signed. As far as the chemical test and all that, he don't sign. We don't mark none of that, right? Just the blood test. You said, did he accept me? Did he agree to the blood test? You agree to the blood test, brother?
No, you gotta admit to the guilt.
Huh?
I admit the blood test. What you saying?
Yeah, he already said he admit to the guilt, but did he need to take blood test?
Stop it right there,
Yeah, you got to submit to the.
please. Officer, I'm sorry, Mr. Tripton, go ahead.
And it stopped it at 1 hour, 49 minutes and 40 seconds.
Okay, officer, when you said, but you need to take the blood test, after you said that, would you agree with me that Mr. Moss stares at you for a few seconds?
Yes, there. Yes, ma'am, it did.
Okay. Then you tell him, quote, yeah, you've got to submit to the blood test, end quote. Isn't that right?
Yes, ma'am. That's when he's nodded. Yes, ma'am.
Okay. All right. Would you agree with me that the last statement that you advised to Mr. Moss, it was not a request but an order?
I wouldn't say an order, no, ma'am. But it sounds, you can say if you looking at it and you hear it, listening to it, yes, ma'am. That wasn't my interpretation, no, ma'am. That wasn't my intent.
It wasn't a question, right?
Yes, ma'am. Right.
Okay. And you were wearing your badge and Clayton County Police uniform, correct?
Yes, ma'am. I was.
And you were equipped with your tactical gear and weapons on your person, right?
Correct. Yes, ma'am.
And Mr. Moss was under arrest at that time inside the jail, surrounded by you and other officials, correct?
Yes, ma'am.
And after you advised him of this statement, he nods his head, correct?
Yes, ma'am.
Okay. And no Miranda warning was read to Mr. Moss after his arrest, correct?
No, ma'am.
You only read him the implied consent warning at the scene before formal arrest, right?
Correct.
Even though he refused, you could have filled out a blood warrant against him if you wanted to, right?
Yes, ma'am.
But you didn't, correct?
Correct.
Nothing further from defense.
All right. Any follow-up from the state?
Briefly, Your Honor. Officer Shelby, you had Mr. Moss sign a document. Is that correct?
Yes, sir.
What did that document say?
I can't, to be honest, I can't right now to tell you.
Did it relate? Do you recall whether or not it related to the blood test?
Yes, sir, it was.
Okay. Let's see. Do you recall whether or not it went over any of or any of the information that was present in the implied consent warning?
Correct. Yes, sir.
How much of the implied consent warning did it go over?
I don't think it went over the consent. It just saying he's submitting to the blood. That paperwork.
Okay.
And Mr. Tipton, I'm sorry, can you put your screen down so I can see the witness?
Oh, my apologies.
Thank you.
And let me remove myself from the spotlight so that so the witness can be seen. So so just so I can understand, you provide him a document that included included a place for him to consent to a blood test. Is that correct?
Yes, sir.
Your objection, Your Honor, that's The state's on direct, not cross. Leading.
Sustained.
Oh, what was the purpose of the document that you handed him?
For his signature for the blood draw.
Did you give him ample opportunity to read the document?
Based on the video, no, sir. Just showed him where he should sign.
Okay. I have no further questions at this time, Your Honor.
All right, anything else from defense?
Nothing else from defense, Your Honor.
All right, may this officer be excused?
Yes, Your Honor.
All right. All right, argument.
Yes, Your Honor. I think defense goes first.
Okay.
Your Honor, Mr. Moss's Fourth Amendment rights were in fact violated by the state because his consent to the state-administered test of his blood was done under the coercion of Officer Shelby. The rule, Your Honor, is in order to figure out whether a person's consent to a state-administered test mentioned in the implied consent reading was involuntary, under coercion, and therefore a violation of a person's Fourth Amendment rights, the Court of Appeals in Kendrick v. State stated Georgia courts must conduct a totality of their circumstance analysis. A consent to search will normally be held voluntary if the totality of the circumstances fails to show that the officers used fear, intimidation, threat of physical punishment, or lengthy detention to obtain the consent. Nor may consent be coerced by explicit or implicit means by implied threat or covert force. This is supported by Kendrick v. State. No matter how subtly the coercion was applied, the resulting consent would be no more than a pretext for the unjustified police intrusion against which the Fourth Amendment is directed. And this is coming from Schneckloff versus Bustamante, 412 U.S. 218, 1973. Other factors to be considered are prolonged questioning, the accused age, level of education, intelligence, and advisement of constitutional rights, and the psychological impact of these factors on the accused. Moreover, while knowledge of the right to refuse consent is one factor to be taken into account, the government need not establish such knowledge as the sine qua non of an effective consent. This is coming from Kendrick v. State. Instead, the court should consider whether a reasonable person should feel free to decline the officer's request to search or otherwise terminate the encounter. Mere acquiescence to the authority asserted by the police officer cannot substitute for free consent. Here, Your Honor, you heard and observed through Officer Shelby's body-worn camera that he read the implied consent notice for suspects age 21 and over. As you've observed, Your Honor, the reading was done before Mr. Moss's arrest, and Officer Shelby did not designate a test during the reading of implied consent. In his body-worn camera video, Officer Shelby asks, quote, "Do you submit? Do you want to go through the testing?" End quote, after he finishes reading implied consent without designating an actual test to Mr. Moss. In response, Mr. Moss affirmatively says, quote, "No," end quote, at 8 minutes and 15 seconds of Officer Shelby's body-worn camera video, thereby indicating his refusal of implied consent. Video evidence shows that Mr. Moss was formally placed under arrest at 8 minutes and 36 seconds. During Mr. Moss's intake process, while under arrest at the jail, you can hear Officer Shelby ask another official where Mr. Moss has to sign in a document. Your Honor, you can also hear Officer Shelby confirm in the video that he did not have to mark anything related to the chemical testing on the document. Then you can hear Officer Shelby ask the official, quote, "You said, did he agree to the blood test?" End quote. Officer Shelby then directs himself to Mr. Moss and asks, quote, "Do you agree to the blood test, brother?" End quote. At that point, Mr. Moss again responds, "No." Officer Shelby then tells Mr. Moss in the body-worn camera video that he had already admitted to the guilt. Officer Shelby says this because he had prior knowledge that my client had refused implied consent twice already. Officer Shelby orders my client that he needed to take the blood test. Mr. Moss then stares at him. Mr. Moss only consents to the blood test by nodding when Officer Shelby says to him, quote, "Yeah, you have to submit to the blood test," end quote, at 1 hour, 49 minutes, and 41 seconds of Officer Shelby's body cam video. Your Honor, my client at that point in time had been under arrest for about 1 hour and 40 minutes. This was not a valid consent made by my client based on the totality of the circumstances, as he was under arrest and was told by the officer that he needed to take the blood test before he consented to it. It was coercion by explicit means because Mr. Moss felt compelled to consent to the test when Officer Shelby said he had to take it. It was an overt statement used by Officer Shelby intended to induce compliance by Mr. Moss while Mr. Moss was under arrest. It is also evidence of Officer Shelby's abuse of power and that Mr. Moss would not have felt free to decline Officer Shelby's order to submit to the test while inside the jail and under arrest. The statement was an order by the officer and not even a request. Therefore, Mr. Moss had no choice but to nod to the order while under arrest. A reasonable person at that point in time would not feel free to leave and therefore would feel compelled to comply with the orders given to them in the jail. The state has the burden of showing that Mr. Moss's Fourth Amendment rights were not violated. However, I can assure you, Your Honor, that the state did not meet their burden, as the evidence of my client's violation of his Fourth Amendment rights are clear as day in the video. Therefore, this honorable court should find that Mr. Moss's Fourth Amendment rights were violated by the state because his consent to the state-administered test of his blood was done under coercion, and thereby the search was non-consensual. Moreover, this honorable court should suppress evidence of Mr. Moss's blood test results as it is the fruit of the poisonous tree. Nothing further.
Mr. Tipton?
Yes, Your Honor. So as the court is aware, the standard for it is the totality of the circumstances under Williams v. State, 296 Georgia 817. And Your Honor, in Williams, it states that it must be knowingly and voluntarily done without coercion. Your Honor, in this case, the officer did attempt to place the defendant on notice with regard to the implied consent by reading him the appropriate implied consent card. He then at a later date determined that time attempted to see if the defendant would be willing to consent to the implied consent. At that point, he gave the defendant a document that was a release for the blood test. The defendant then was given an opportunity to review the document and signed off on the document. The defendant did ask if he was admitting to the DUI by signing the document. The officer said he was not admitting to the DUI by signing the document. Your Honor, I do want to bring the court's attention to State v. Clay, that 39 Georgia 473, specifically the portion that is at the lower portion of page 474 and ends at the beginning of 475. There, the defendant was arrested. Implied consent was read. The defendant stated, quote, "So you're going to draw my blood? All right, I submit." And an electronic consent form was filed. Later on December 31st, an order granting Mr. Clay's motion to suppress was signed. There, the court determined that, let's see. There, the court determined that even though the trial court found that no apparent coercion had occurred, the even though the trial court had determined to suppress the case, the Court of Appeals overturned the suppression based on, and I apologize, Your Honor, I'm having some technical difficulties. The fact that the officer did not in any way coerce, threaten, use physical resistance, or otherwise act in a way that was forceful towards the defendant and to coerce the defendant. For that reason, Your Honor, the state requests that the court will deny the motion. Thank you. Nothing further from the state.
All right. Based on the totality of the circumstances, the court does find that the reading of the implied consent prior to arrest, as well as the coercive nature of Mr. Moss being in custody at the time that the officer attempted to confirm that he had agreed to what was later determined to be a blood test, which was not done at the time that the implied consent was read. The court does find that there was a coercive nature, and then the order in which the applied consent was read, the arrest was conducted, and the different actions taken by the officer to secure the consent to the blood test were coercive in nature. And at this time, the court will grant the motion to suppress and find that the fruits of the blood test should be suppressed as the motion is being granted.
Thank you, Your Honor.
All right, Ms. Powell is going to get you an order, but I wanted to make the statement so that if there's movement that needs to be done on this case, then you all can begin that process.
Thank you, Your Honor.
Thank you.
All right, so is there anything else at this time? I believe that was the last thing that we had on the calendar.
That was the last thing that the state had on the calendar, Your Honor.
All right, well, we will see you tomorrow. Thank you.